Excellencies, ladies and gentlemen, this is the fourth and the last panel of today, and it is indeed a great pleasure for me to participate in this event. And thank you, Ögmundur, for entrusting me for chairing the fourth and last panel. Luckily, the Prime Minister's office is close by, so I have been able to be with you at least for 1 or 2 hours today, which is great. The topics that have been discussed today are, of course, all very urgent and important. And as you know, 2016 is a year of several important anniversaries. The two 1966 UN Covenants on Civil and Political Rights and Economic, Social, and Cultural Rights and the UN Human Rights Council established in 2006. And with that took over from the previous Commission on Human Rights. Usually anniversaries provide the international community with an opportunity to reflect honestly and openly on what has been achieved and where improvements should or must be made. And as you know as well, together the Human Rights Declaration from 1948 and the two previously mentioned covenants make up the so-called International Bill on Human Rights, And great achievements have been reached since this period, and of course many other human rights conventions have followed. In this panel, we will focus on human rights conventions, international governance, state prerogatives, and non-state involvement. And I have to complain a bit, Ögmundur. You gave me the panel with all the difficult surnames, so I will be in deep trouble in trying to pronounce. All right, good. That's good. We have excellent panelists that are going to talk about different aspects related or within the main theme of the panel. And I kindly ask the panelists to try to stick within 7, 10, 12 minutes time frame. And with those words, I would like to introduce our first panelist. And we are with first names. Yes. Good. Christos.
Thank you.
He is the Director of Human Rights in the Directorate General on Human Rights and Rule of Law of the Council of Europe. He was recently appointed Special Advisor of the Secretary General for Ukraine. And he's going to talk about enforcing human rights regimes, the collective responsibility of states and non-state actors. You have the floor, sir.
Thank you very much, Ingeborg. First of all, I would like to thank you, Ögmundur, first of all, for having invited me, and also the Institute for Cultural Diplomacy for having organized this gathering, which I have enormously appreciated since this morning, and I would even say since yesterday evening. The previous panel has focused on the failures of the international community to secure a number of human rights, suggested to reform the international framework under which human rights are guaranteed. The present panel deals with human rights conventions, so although I will agree with the previous panel that there have been a number of failures of the international community in guaranteeing human rights, I would certainly say also that it is better not to change the conventional framework for the protection of human rights, since, at least in my opinion, it is based on the collective and painful experience of the Second World War, and it has concentrated and absorbed this painful experience and tried to preserve the human rights from further violations. Let me start by saying I would like us just put some very basic questions and try to reply to them. My speech will not be very optimistic, I'm afraid. So why do we have human rights conventions? Obviously, because we need to transform a declaration, the United Nations Declaration of 1948, into concrete obligations, international obligations. It is binding. We talk about binding obligations, obligations that come under the scope of international rule of law. We also talk about conventions because in this way we have a collective responsibility for their implementation and not only the responsibility of a state against its own citizens as we have under the constitutions. So we have conventions, binding obligations between member states to protect third persons who are the real beneficiaries of these international agreements. And this is a specific feature of human rights obligations. Two persons, two international entities agree to protect the rights of a third one, which means that the beneficiary has a role to play, although he or she is not a party to these agreements. The third one is that it introduces an external element of control, an international control, which also shows that the experience of the Second World War has shown that member states are not their constitution is not a sufficient guarantee for the protection of human rights, as there is a need to have a collective responsibility for the protection of human rights of people. Now, what the Council of Europe, which I serve, has transformed that into a number of conventions, the European Convention of Human Rights, the European Social Charter, and as you said, Madam Chair, a number of other instruments, the Framework Convention for the Protection of Minorities, the Convention on Trafficking of Human Beings, more recent instruments such as the Convention for the to combat violence against women and domestic violence, sexual exploitation of children. And these are treaties, international treaties with binding rights and obligations. And it has also instituted international mechanisms for that. The European Court of Human Rights, the European Committee of Social Rights, a number of other mechanisms which are quite intrusive in the domestic legal order, as for instance the Committee for the Prevention of Torture, which has an unlimited right to control places of detention without previous advice. And of course, all this only works to the extent that the member states are the main those who carry the obligations, who have the obligations. The control mechanism is also subsidiary. Is only subsidiary. So rights, we talk about law, the rights are enforceable, they must be justiciable, people must have access to justice to claim their rights. There must be a process and a procedure for these rights to be claimed, and this is the very essence of the Human Rights Conventions. We talk about law, we talk about the role of the beneficiaries, access to justice for beneficiaries, and not only an ideology or ambition, rights as that human rights are ambitions, as we sometimes say about social and economic rights, but they are real, enforceable, justiciable rights that can be claimed. Does this system work? We heard that it doesn't really work very well all the time. I would say that in many cases it worked, and it still works, but there are some moments where the whole system doesn't work really well. And the worrying thing is that these moments become increasingly frequent. I would list some of them. First of all, the fight between liberty and security. It's not a new issue. It has always appeared as a fight between liberties and security. How far can you restrict liberties, freedoms, in order to protect the society from crime and nowadays from terrorism? But there are more problems, more discourse, more rhetorics that put at risk the international conventional protection of human rights. And these relate to the fact, for instance, that these instruments are outdated. We heard that on several occasions concerning the Geneva Convention during the refugee crisis. We listen that the ILO conventions are outdated, that they do no longer belong to that they are not adapted to the situation as they are now. The European Convention of Human Rights also is an outdated instrument going back to the 50s, which is not adapted to the present situation. Sovereignty is another element that comes into play very often to put a challenge to the conventional obligations of member states. Russia, for instance, has, as you have possibly heard, but also Azerbaijan recently, entrusted its constitutional court to decide whether judgments of the European Court of Human Rights can be implemented. So there is a creation of an artificial conflict between international and national legal order. Sometimes this is also put on the account of democracy. The United Kingdom Parliament, for instance, has, or probably the Prime Minister, I would say, has claimed that the United Kingdom Parliament cannot implement a number of judgments, one judgment of the European Court of Human Rights, because it does, actually he said that the judgment makes him sick. I think this was the only explanation that was given. So there is also, there is a number of statements, of positions, of rhetorics that actually aim at restricting the binding nature of these instruments and to, as again the Prime Minister of the United Kingdom said, clip the wings of the mechanisms that are to implement these and control the implementation of these instruments. The international community tries to overcome these problems with very classical means. Usually it is political peer pressure, economic sanctions sometimes, or internal pressure from the opposition or the public opinion. Now, both are under challenge today. First of all, because international pressure and sanctions do not necessarily work well when we talk about human rights, because actually the ones who are sanctioned are the real beneficiaries. So when you cut cooperation with a state which is violating human rights, usually the situation is not improved for the real beneficiaries of the rights. It even sometimes becomes worse because they are more exposed to the arbitrariness of the state concerned. But at the same time, the national opposition is becoming less effective as it used to be some 10 or 20 years ago. The public opinion is less willing to engage in human rights, as we see with the increasing extremist rhetorics that appear in our member states' political life. And this is because the protection of human rights as a position taking by the national public opinion has been undermined and criticized and discredited, whether it comes from the NGOs or from the academia or from trade unions, as unrealistic, as utopic, as human rightists, as they sometimes say, because it is too legalistic, which means that, not adapted to reality, or because it serves foreign interests. We see that NGOs, for instance, in Russia are qualified as foreign agents, because it is corporatist, because, for instance, it protects the rights of some workers or from judges or whatever, because it is intellectuals, which means that they are not people linked to the realities, but they are somewhere in the sky. How do we face now the situation, this slippery road that the international protection of human rights has taken? I would say, first of all, I would like to stress that this is a very slippery road because it actually does not only undermine the protection of human rights, it undermines international rule of law and progressively also national rule of law and, of course, ultimately also democracy, because all these things are completely interlinked. I think that the way out of this is the empowerment of the civil society to address mainly the national institutions that are capable to protect human rights and also protect the rule of law. Because the interests that lead to this deregulation of human rights in general need nonetheless a certain justice system need a certain security, a certain certainty at the legal sphere, the only ally that human rights have in this process of deregulation is domestic courts, domestic national human rights institutions, ombudsmen, or other institutions that are capable to engage at the domestic legal order and before we reach the international litigation with the effective implementation of human rights. So I would say 3 avenues: domestic litigation, including, of course, court litigation and constitutional litigation when this is possible, empowerment of the civil society, in particular of the trade unions, to have access to these instruments, and mediation or involvement of national human rights commissions and above all of the ombudsman in the human rights litigation, the domestic legal order. This is the best way to protect human rights at this stage, where I think human rights are leave difficult times, probably the most difficult times since the Second World War, and the institution that I serve has been precisely created to protect human rights from this situation, has lived for more than half a century an easy life, because everyone was protecting human rights, or believing that human rights are a value that needs to be protected. And we now feel, since 10 or perhaps a little bit more years, that this tendency is reversed, and that human rights are no longer the basic value on which our societies are based. Other considerations, national security, budgetary feasibility, are more important than the values that you have so far supported. Thank you very much for your attention.